Good morning, my name is Bruce Provan. I'm the Managing Director of Page Provan. We're a law firm in central Brisbane that practices exclusively in family and fertility law. I want to talk to you today about self-represented litigants, or acting for yourself in proceedings in the Federal Circuit and Family Court of Australia. Now, obviously most people who go to court in family law matters have a lawyer to represent them, but there are a number of people who either can't afford a lawyer or don't think that they can justify the cost of engaging a lawyer for the process, and so they represent themselves in court. And it's becoming more and more common for people to represent themselves in court, especially at the early stage of the proceedings. Now, normally when you engage a lawyer, you engage them to do everything in the matter. That is, to do all the communications with the court and with the other party, to do the court appearances and the preparation of all of the necessary documents. But you don't have to engage a lawyer to do that. And what we sometimes find is that clients come to us and we explain their options, and they choose to do part of the work themselves and to get us to do part of it for them. So, for example, a client may decide that they want to do the court appearances themselves, but engage us for advice and to help them with preparation of documents. And that's fine, because obviously the more someone does for themselves, the less the cost is going to be. My advice is, if you can afford it, to engage a lawyer for the whole process, because you're going to get better representation and better advice and probably a better outcome. But I appreciate that for many people that's simply not possible. And many people do a good job of representing themselves in court. For the past few years, Section 102NA of the Family Law Act provides that where a person is representing themselves and there has been allegations of domestic violence, they can't cross-examine their former partner or spouse. So what now happens where there are allegations of domestic violence and a matter is approaching a final hearing? The court will usually make orders pursuant to Section 102NA for the parties to have representation. Now, the way that works is that in the month leading up to a final hearing, someone who's representing themselves or someone whose lawyer has stopped acting for them can approach Legal Aid Queensland or the Legal Aid Office in another state and request for a lawyer to be appointed to represent them at the hearing. And the Legal Aid Office will then appoint a lawyer from their panel to represent that person at the hearing, and it's not means tested, it's usually free of charge. So if you decide to represent yourself in proceedings, one option is for you to engage a lawyer privately at the start of the matter, and as the matter gets towards a trial, to engage a lawyer from the Section 102NA panel to represent them at the final hearing. So it's my suggestion that if you do decide that you want to represent yourself, at least get some legal advice at the beginning so that you know what you're entitled to and what the process is, so that you can make an informed choice of which parts of the matter you do yourself. It's also a good idea, as the matter proceeds, to come back to the lawyer to get further advice so that you're aware of what the likely outcome is going to be, and so that you could engage in some negotiations, but at least have some information that's going to assist you along the way. My name is Bruce Provan from Page Provan, Family and Fertility Lawyers.